Hello everyone and welcome to this Privacy Rules, Privacy Espresso episode. Privacy Espressos are a series of quick session, maximum 10 minutes, where the Privacy Rules members interviews Privacy Rules experts or guest speakers about the most relevant privacy-related topic of the moment. My name is Alessandro Di Mattia, Legal and Executive Officer at Privacy Rules, and I'm very pleased to introduce you today to Robbie Grant from the Canadian law firm McMillan in order to discuss about what's happening in Canada under the privacy law perspective. So first of all, Robbie, thanks a lot for being with us today.
Thank you for having me. Excited to be back on Privacy Rules.
Perfect, Robbie. And speaking about Canada, we know that in Canada there are many different laws, so there is a pretty complex patchwork. May you kindly provide us with a quick overview on which is the current state of privacy laws in Canada?
Sure. So we have a whole suite of different privacy laws, and we have three main types. There are health privacy laws, which apply to health sector institutions in nearly every province in Canada. We have public sector privacy laws that apply to your government bodies, and again, that's in every single jurisdiction in Canada. And then we have private sector privacy laws, which apply to commercial organizations. And that's a little bit more tricky. In the private sector, we have a federal privacy law called PIPEDA, that applies all across Canada, except where other substantially similar privacy laws exist. And so we have those substantially similar laws in British Columbia, Alberta, and Quebec, three provinces. So everywhere else, PIPEDA will apply. And PIPEDA also applies to transfers of personal information between provinces and outside the country, and also to any federally regulated organization, even in those specific provinces.
Perfect. Thanks a lot for this quick introduction. And speaking about which, I mean, you mentioned that you have I would say a pretty complex patchwork of laws that you have, every time to keep an eye on. Which are the main changes that are coming for the new year?
So in the province of Quebec, there are big changes to Quebec's privacy legislation coming in September. They're coming into force. These changes were brought on by Act 25. In brief, they bring the law closer in line with Europe's GDPR, including GDPR level fines. They also include requirements for automated processing, privacy by design, and new policy requirements, among other things. But for today, I think we want to focus on another significant development, which is Bill C-27, which is making its way through Canada's Parliament at the moment. Bill C-27 would enact the Consumer Privacy Protection Act, or CPPA, which would effectively overhaul and replace PIPEDA. So it would have a huge impact all over Canada.
Wonderful. Just one question in this regard, because you mentioned before the relationship between PIPEDA and the specific regulation you have in the different provinces. Will it be the same with C-27?
Yes, it would likely be the same. So it's yet to be seen if, when the CPPA is passed, or if it's passed, whether the provinces will follow suit and start updating their own privacy legislation after that.
Okay. And in this regard, let's speak about this, because I think it's the great point of what's happening there. So what is going to happen in case this bill is going to pass?
Okay, so I'll run you through some of the highlights. First of all, enforcement, as you can expect in our modern privacy world, the enforcement regime is getting stricter, more teeth. There are big fines and monetary penalties for non-compliance, up to 10 million or 3% of global revenue. And then for more serious offenses, up to $25 million Canadian or 5% of global revenue. And these fines would be issued by a new tribunal. So there's a slightly different process for how these fines would be rolled out. There's also a private right of action for individuals who are affected by a contravention, which invites a little more litigation for companies. One huge highlight is new exceptions to consent. So in Canada, we have a consent-based privacy regime, meaning you generally need consent to process personal information unless a narrow exception applies. So one is for certain business activities, such as information security or product safety, where a reasonable person would expect that the collection or use of personal information would occur for that activity.
And second, for legitimate, the organization outweigh any potential adverse effect on the individual, and the organization has conducted an internal risk assessment to establish that.
So that's sort of similar to legitimate interests under GDPR. But interestingly, neither of these exceptions would apply where personal information is used to influence behavior or decisions. So companies would likely still need consent for any types of targeted advertising, for example. More exceptions to consent, the CPPA would clarify that companies don't need consent or would not need consent for transfers of personal information to service providers or in order to de-identify personal information. In other words, to strip away the names from personal information, which were two things that were somewhat vague under PIPEDA. And speaking of de-identification, the CPPA provides a lot of clarity on how it would apply to anonymized versus de-identified personal information. So it explicitly does not apply to permanently and irreversibly anonymized personal information. And some have noted that that's a pretty high bar to meet. A lot of privacy laws will appeal to industry standards for anonymization, but this is permanent and irreversible, period. So hard to say if you can meet that bar. And it also applies to de-identified information, but organizations have somewhat more freedom with how they can use that info. So for example, you can use de-identified data under the CPPA for internal research and development or socially beneficial purposes without requiring additional consent. And closer to the end of these highlights, the CPPA also creates a host of new transparency obligations. And the biggest of these is a requirement for organizations to develop a privacy management program. And so that would include policies, procedures, training materials, and explainers. And this is interesting. The Federal Privacy Commissioner then has the ability to request a copy of that program and then provide guidance and recommendations on it. So this would provide an avenue for the privacy regulator to get involved in a proactive and collaborative way. And finally, consumers get a few new data protection rights. And these are things that exist around the world already. One is the right to request the disposal of their personal information, which was not explicitly provided under PIPEDA. Second is the right for data portability for certain companies, but we don't know yet what those companies will be. And third, the right to obtain information about automated decision-making systems. And so those are the main highlights of the CPPA. I'd also mention briefly, there is another separate act contained in Bill C-27 called the ADA, which is the Artificial Intelligence and Data Act. And that would be the federal government's first real attempt to regulate artificial intelligence systems, which have obviously been getting a lot of media attention lately, right? However, the last time Parliament discussed this bill, there was some criticism of ADA being too vague and a strong indication that it would be split off into a separate bill and considered separately. So while Bill C-27 has a lot of momentum, the ADA might be falling to the wayside this year.
Robbie, thanks a lot for this very, very interesting overview that you have just given us. I see that there is an alignment also between the Canadian regulation and other like GDPR. You've been speaking about other ways apart from consent to get and use their data, new rights, new sanctions that look stronger than before and looks more aligned to what we have. So I really see that there is an effort from many countries in finding, to fine-tune the various regulation in order to be as aligned as possible. And it's also very interesting to see that there is a common, let's say, interest in already start working in the AI sector, because we see that at the European level, there is a lot of work under that specific sector. So a lot of things to discuss about also for our future espressos. I heard about new regulation coming also from your provinces, so something that we should keep an eye on, like the Bill 64 from Quebec, if I'm not mistaken, and then this AI regulation. ADA is the name, if I'm not
ADA, yeah.
ADA. That sounds extremely interesting. So thanks a lot for being with us. We ran out of our time, so I'd like to thank our listeners for being with us and looking forward to meet you all with the next Privacy Espresso. Bye, everyone.